everybody's attention. This is the Standing Committee on Public Safety and National Security, meeting number 16. I'd like to inform everyone that we are continuing our study of the Sex Offender Information Registry Act. It's a statutory review of the Act, and we have before us witnesses from the Office of the Privacy Commissioner of Canada, Mr. Carmen Bagley and Ms. Linda Campbell from the Canadian Council of Criminal Defence Lawyers, Bridie Bethel, and as individuals, Anna and Jim Stevenson. We welcome you all to our committee, and I think you have agreed to go in the order that I have just listed. You may introduce yourself and also maybe just describe, give a brief resume of yourself. Okay, Ms. Bagley, Mr. Bagley, sorry, if you would like to begin.
Thank you. Good morning. My name is Carmen Bagley. I'm a strategic privacy advisor with the Office of the Privacy Commissioner of Canada, and I'm here with our General Counsel, Lisa Campbell. We're pleased that we were asked to appear to comment on the Sex Offender Information Registration Act. Our office has an obvious interest in the Act. The Act requires convicted sex offenders to register with the police and, after they've been released, regularly inform the police of their movements. In addition, they're required to provide personal information, telephone numbers, secondary addresses, and other information that potentially allows the police to contact them. These are requirements that are not imposed on other types of offenders who have completed their sentences. We understand why this is the case, given the seriousness of the offenses. Nonetheless, this is a significant intrusion of an individual's privacy, an intrusion that can only be justified on the grounds that it produces a clear and demonstrable public safety benefit that cannot be achieved through less intrusive means. One way to assess the reasonableness of the inherent intrusiveness of the legislation is to look at its effectiveness. We know that questions were raised about the potential effectiveness of the registry when the legislation was first proposed, and we're not aware of any formal evaluations that have been done since the Act came into effect that directly answers these questions. We're also aware of the testimony that the committee has heard that casts doubt on the effectiveness of the registry. Assessing the effectiveness of the scheme is very important. If it's not effective, then the privacy intrusion is for naught. Sacrificing someone's privacy in the hope that this may protect society is a dangerous precedent. We expect that the committee will hear many suggestions to improve the registry, and we expect that many of these suggestions will involve expanding the scope of the regime. This could involve a number of possible changes, such as increasing the number of designated offenses, eliminating judicial discretion with respect to the issuance of orders, allowing greater or broader use of access to the registry. We would urge the committee to avoid trying to improve the effectiveness of the registry by allowing its broader use. Providing public access to the registry or allowing it to be used for community notification could be counterproductive. Incidents have occurred in both the United States and the United Kingdom in which members of the public have attacked and even killed people suspected of being sex offenders based on information contained in the press or accessible through the Internet. In addition to the harm caused to the offender, or in some cases people wrongly thought to be an offender, this publicity may be counterproductive. It can drive offenders underground and make them less likely to comply with registration requirements. One of the purposes of the Act is to help police investigate crimes of a sexual nature by requiring registration of information related to sexual offenses. making changes to the Act that would reduce the likelihood of compliance runs counter to this purpose. Publicizing the identity of offenders may also make them less likely to seek treatment, and it could make it harder for them to establish a stable environment, increasing the possibility that they may reoffend. We did not come here this morning to urge the committee to recommend withdrawing the legislation. We know this isn't going to happen. We know there is considerable pressure to change the legislation. We would urge the committee to look at any proposals carefully, particularly proposals that would increase the amount of information being collected or disclosed or expand the permitted uses. There may be ways to make the scheme more effective, perhaps through increased resources or through procedural changes that would enhance the effectiveness and value of the legislation without increasing its intrusiveness. We'd like to conclude by offering two specific suggestions. First of all, we think there should be greater transparency and openness about the program. For example, we weren't able to find any information on either the RCMP's website or Public Safety's website about the number of registered offenders. In contrast, one can look at the DNA Data Bank. It publishes an annual report. You can go to its website and find out a great deal of information about how that program operates. The other recommendation that we would make, and we think this is critically important, that there should be a formal evaluation that's done with respect to the effectiveness of the legislation. And this should be done by an independent third party. And we would strongly recommend that this evaluation be done before any significant changes are made to the legislation. Thank you for your time. We'll be pleased to answer any questions you may have.
Okay, thank you very much, sir. We'll now move over to the Canadian Council of Criminal Defence Lawyers. Ms. Bethel, please.
Thank you. My name is Bridie Bethel, and on behalf of the Canadian Council of Criminal Defence Lawyers, I'd first like to thank the committee for the opportunity of being here, as well as Mr. Bagley and Ms. Campbell for their comments. And I'd also like to commend Mr. and Mrs. Stevenson, who are here this morning, and for the courage that it no doubt takes them to do so. As you probably know, the Canadian Council is a national council as compared to some of the other organizations in the country that has representation right across the country, from coast to coast, including our 3 territories in the north. We offer a national voice, not on behalf of Defence Counsel, so much as the administration of justice in relation to the preservation of due process. We're very grateful to be here, and it is the Council's hope that we can assist the committee in any way that we can. This is not an easy issue. This issue strikes at the core of our hearts as human beings and as parents, as many of us in the room today are. All of us want to protect our children and our communities. It's almost impossible to think that we would not do anything in our capacity to do so. The issue also strikes us, however, at the core of who we are as citizens in this country. The reason that Canada is the envy of the world in many respects is because we as citizens have sought to uphold the principles of democracy in the choices we make for our communities. We compromise and we balance. We balance competing interests. I'm sure none of you believe this, and I hesitated about whether I would say exactly this, but it's often the case, and this is true among my friends as well, that as a defense lawyer that I protect the rights of offenders, and that's not what I'm here to do today. We are all here together today as citizens to figure out what the right thing to do is with respect to the National Sex Offender Registry, and I don't think there is anyone here who would disagree with me that we are here to strike, we are not here to strike the appropriate balance, to step back and look dispassionately at what we have, what's missing, what's needed, and why we are doing this. This is not a we-they issue, but it is an issue that requires us to balance individual and collective rights. The criminal justice system in this country exists because it is the system to which we turn to address wrongs committed against society. We don't address those wrongs ourselves. When a criminal offense, for example, of a sexual nature occurs, we don't put a sign on someone's lawn because we think that person has done it. We go to court to have the problem addressed appropriately. I'm not here to tell you what the law should be. It's up to you as parliamentarians to decide what the law should be, but I view my role here today as to help you decide what the balance should be. In doing so, I would urge you to consider the following questions, and I hope that these two questions will help you to frame the way in which you will approach the solution to this problem. First, what is the purpose or goal of the registry, and what are the purposes of the proposed changes? And second, if the changes are made, how would this affect accused persons across the country, not just here in Ottawa, but the farmer in Saskatchewan, Aboriginal persons working the seasonal trap lines in fly-in communities in Nunavut? It's my understanding that there are serious concerns about the effectiveness of registries in either solving or preventing reoffending, and I emphasize the word reoffending. Two possible reasons for this are as follows. Registries can do little, if anything, to capture first-time offenders. The registry is about catching reoffenders. Second, the majority of sexual assaults occur between people who know each other, family, friends. So it is a serious question to ask whether registries in fact make society safer and at what expense. On the practical level, resources are another factor to consider. Resources, as parliamentarians, we all know, are not infinite, but demands, both financial and administrative, are. So there are choices to be made when making sensible investments in our law enforcement policies. The question, I think, is what is the best way to spend our limited law enforcement dollars, especially when we marry this question with the serious issue of effectiveness. Also relevant when considering whether registries add value to the process is the fact that there are alternatives already functioning in the criminal justice system. For example, we have the ability to make designated offender designations, as well as the ability to make long-term offender designations. There are others. The 810.1 peace bond provision in the criminal code, and probation generally, which is designed for rehabilitation, social integration, and which is tailor-made to the needs and requirements of the offender and the offense. My final point is a note about discretion. An integral part of the criminal justice system, in my view, is the ability of judges and prosecutors to deal with the offender and the offense on an individualized basis. This is consistent with another principle of our criminal justice system, which is respect for the independence of the judiciary. When we give judges and prosecutors discretion regarding who is placed on the registry, rather than requiring placement and permitting exceptions on a high test of grossly disproportionate, it takes away from the ability of judges and prosecutors to use discretion. This is a national registry, so its impact must be considered with respect to all Canadians. And I would ask you to consider whether it would be a principled approach to take away from the ability of the present registry to individualize and not arbitrarily sweep up all persons based on the class of offense. So to return to my main theme this morning of balance, the difficulty of resolving the issue between getting the compromise right between collective rights and individual rights. The question we're all here to answer is, what are the reasonable limits on a person's rights and freedoms in pursuing the particular objectives of this legislation? We must be alert in answering that question that we do not use means that are broader than necessary to accomplish that objective, which is an inherent principle of our Constitution, that is, to not go overbroad in achieving that objective. We all feel the need emotionally to respond to serious tragedies, but we must react to legislation and proposed amendments on a principled basis. Those are my submissions. Thank you.
Thank you very much. And we'll now turn to Anna and Jim Stevenson. Who is going to present? Mr. Stevenson, go ahead, sir.
Good morning, Mr. Chair. Good morning, committee members and other witnesses. My name is Jim Stevenson. This morning I am joined by my wife, Anna, and we are here today to share our views and concerns about the National Sex Offender Information Registry Act and the NSOIRA, as the acronym is probably more commonly understood, to share our concerns and with you. With all respect for the viewpoints and perspectives submitted earlier this week, together with those which we have heard in introductory remarks today, we believe we believe you will find what we have to say this morning somewhat unique. Unique not only for the reason that we are the parents of a child abducted, sexually assaulted, and murdered by a known convicted sex offender, but also because of our determination to see to it that communities will be better protected from such offenders than we had been. To accomplish this, it was necessary to bring about significant systemic changes in the manner by which authorities manage convicted sex offenders released into communities. Earlier this week, you heard testimony about the legislation which created Ontario's sex offender registry in 2001. That legislation, of course, is named Christopher's Law in the memory of our 11-year-old son who died very violently and tragically on the 1988 Father's Day weekend. Ontario's sex offender registry is proactive. Registration is automatic following conviction of a criteria offense. Law enforcement officers are proactive in consistently verifying the information contained in the registry's database to ensure it is up to date and completely accurate. And more importantly, the information is available for sharing with other police agencies investigating sex-based crimes. These features alone underscore reasons for the provincial registry's success. The NSOIRA was proclaimed in early 2004 and became operational later that same year. More than 10 years after a 1993 inquest into our son's death had recommended the federal government move immediately to create a national sex offender registry. In statements we made during public hearings into the proposed legislation over 5 years ago, we expressed serious concerns relating to a range of features of that legislation. We were troubled then, as we continue to be troubled today, that registration does not follow automatically upon conviction. Our concerns today are heightened more so when we learn, as you did earlier this week, that nearly one half or 50% of those convicted of criteria offenses are literally excused by the courts from being required to register without those same courts providing explanation for such disposition, which is clearly stipulated in the legislation. It is my understanding, as it is, I'm sure, everyone in the room, that federal offenses are more serious than those dealt with through the provincial courts. Yet in the case of the latter, in the provincial system, registration is automatic for all convictions named under the legislation. Mr. Chair, committee members, to me, it just doesn't seem to make a great deal of sense. I would respectfully submit that if the judiciary do not comply properly with their responsibilities under the legislation, then it is broken and badly in need of major repair. In the words of a popular home repair television personality, let's make it right. From the time the federal piece was first being developed, we have held concerns over the effectiveness of the National Registry, and I have often been quoted as referring to it as a notional concept of a sex offender registry. Unfortunately, I believe the public has been misled into assuming practical safeguards are in place for their security and protection, when this, in fact, is not the case. There is, in fact, a troubling parallel between the state of the NSOIRA and a fairy tale that we would often tell to our son and daughter when they were very young. The tale involved a monarch who desired a new wardrobe to impress his subjects when he frequented the town and surrounding countryside. He would not consider many of the designs submitted by the court tailor, who had for many years been responsible for the king's wardrobe. Although many of his advisors felt the designs were truly exceptional. Finally, after considering many different designs from many of his loyal subjects, he appointed a lowly stable boy to design his new wardrobe. The trouble was, the stable boy knew nothing of clothing design, and convinced he would suffer dire consequences if he could not come up with something his monarch would accept, he determined finally to convince the monarch that he had created an invisible fabric that was superior to anything yet seen. In fact, the stable boy had created nothing and counted on his ability to convince his king that he was outfitted in the finest cloak and investments ever seen. In the end, a completely naked monarch walked among his subjects, convinced he possessed the most wonderful and unique outfit. At first, no one dared tell the king the truth. But finally, a young man who had been watching a procession in which the king was involved in uttered the words, to everybody's surprise, "But the king has no clothes." And the villagers all broke out into laughter, and the king then realized his folly. Mr. Chair, committee members, I submit in its present form that the NSOIRA has no clothes either. It is dysfunctional and fails to properly protect Canadians from becoming victims or from being re-victimized by offenders released back into their communities. Earlier, I'd mentioned that our presence here might be considered unique and provided some reasons why. Let me close my opening and formal remarks this morning by adding one more argument for this uniqueness. On the one hand, those parties appearing before you have done so as part of their job, and it is safe to assume that they have been paid for their time. On the other hand, Anna and I speak to you today because we have paid and paid dearly to be here. No doubt that distinction will be weighed carefully in the final determination that this committee will make on the future direction of the National Sex Offender Registry. We look forward to questions from the Chair and members of the committee during the remaining time available here this morning. Thank you.
Thank you very much, and we appreciate your appearance before this committee. As is the usual practice, we will begin questions and comments with the official opposition. And Mr. Oliphant, you will begin. Okay, go ahead, sir.
Thank you to all the witnesses. We're very happy that you're here as part of this review. This is part of that independent review. The parliamentary committee has that ability to look at this legislation, and that's exactly what we're doing. And at the end of this, of course, we'll be making recommendations to the government about this legislation. A couple of questions for Mr. Bagley. You mentioned in your statement that we understand why this is the case given the seriousness of these offences. I think it's also the nature of the offences and the nature of the offenders that have provoked this kind of legislation. Not just the serious, there are many serious crimes, but my sense is that we have this legislation because the nature of some offenders and their potential to reoffend is different than other offenses. And while I respect and, in fact, treasure our privacy, does the Privacy Commissioner actually think there are some offences that do allow or even demand the lessening of one's privacy?
I'll start. Well, certainly, we recognize that people who've been convicted of offenses have a reduced expectation of privacy. As it turned out, yesterday we appeared before the Senate to discuss the review of the DNA Identification Act. That's an example of another piece of legislation that's based on the assumption that people who've committed certain offenses have a reduced expectation of privacy. Having said that, we certainly, however, don't believe that someone has no expectation of privacy, that it's completely eliminated as a result of offending. And the question I think that we would ask you to consider is whether there is a clear benefit from this regime that justifies the reduction in the privacy of the individuals in question. And we've heard a great deal of evidence about the effectiveness of it, and the question you should, I think, ask is whether or not it's possible to make changes that would, in fact, enhance the effectiveness to further justify that reduced privacy.
With respect to those changes, in your early text, your major concern seems to be the expansion of the use of the registry into non-police agencies, into public use, into access by other agencies that may be interested or people that may be interested. But at the end, which is my grave concern as well, I will acknowledge that I don't want people to have a public registry. They can Google someone and find their name. That, to me, is totally inappropriate. This is for police agencies. But later, you talk about the amount of information being collected. You just mentioned at the end of your presentation. Seems to me to make this more effective, the amount of information that a restricted number of agencies would have, the police agencies, could improve the effectiveness and yet not expand the use of the registry. And I'm just wondering whether you agree with that or whether you want to push back on that.
Well, I think we'd have to see what additional information that's proposed would be collected. There is a significant amount of information that's collected now. I understand that there is some debate about the fact that the taking of photographs isn't mandatory, but I think it would really be a question of what other pieces of information are we talking about, and we would look at that and again sort of look at it using a kind of proportionality test depending upon what was being proposed.
I guess I'll be ending up pushing back on that, because if there is some identification information there, but not enough to make it effective, you might as well not have any. Because if people don't have, if the police officers don't have enough information, it's just not going to work. But we'll get to that later. Ms. Bethel, thank you for your remarks as well, and I've spent lots of time with offenders and appreciate due process completely. And I think you're absolutely helpful in us, reminding us that Canada is based on due process and all that. One area I wanted to ask you about, some of the alternatives to the registry, such as Section 810 peace bonds, those kinds of things, have also been criticized as not being as effective as they could be, and some probation theme. Have you, has your association made representation to anybody about how we could improve some of those alternatives? Probation, designations, long-term offenders, designated sex offenders?
I don't know if the council has made any submissions on that, to my knowledge, so I'll leave that aside because I just don't know the answer to that. But I can tell you that the system isn't perfect, and there are lots of things that we can improve on in the present tools that we have, both in terms of crime prevention and crime investigation. One of the main criticisms, of course, for any kind of supervisory order which is true for probation and long-term offender designations, entail a type of probationary supervision, is that there aren't enough probation officers, and the rehabilitation side and treatment side of our criminal justice system is lacking in resources. So I guess that comes back to the point I made about how we decide where our money goes. Does it go to the rehabilitation side, or does it go to the registry side? Can the two interact? Can the two work together? Can there be some way of coming to a middle ground so that the two regimes can work together? That may be, but sorry.
One last, because my time's limited, one last question. I appreciate, in fact, again, value judicial discretion. I absolutely believe in it. I also believe that there should be a possibility that of a double judicial discretion, not only to lighten or lessen. That's why I tend to not believe in mandatory minimums, because I think judges need to look at every case individually. But also, I think that there are times when they should have discretion to increase penalty, such as in multiple incidents where, you know, the 17th offender isn't even heard at trial, as in BC or in several other cases. Has your association had any discussion on giving judges more authority to have discretion on the other end to increase penalties?
I would disagree with you. I think that that already exists, because the ability for the Attorney General to make a dangerous offender designation, that application comes from the Attorney General's office, but the decision is ultimately made by the judge. And for a dangerous offender designation, the offender remains in custody indefinitely, and so long as that offender is deemed a threat. The LTO designation, the long-term, offender designation, carries not an indeterminate length, but a much greater custodial and punitive aspect to it. So I wonder whether or not that doesn't already exist.
I'm thinking of non-custodial,
Okay.
moving into non-custodial effects beyond probation. I'm just
Beyond probation.
trying to open up the box to look at some new ways that we can actually deal with this.
We can come back to this issue maybe a little later. Yeah, the time is up. Monsieur Menard, please.
First, I'd like to thank all the people who come to witness before us with rather high-quality presentations. And as for the Stephenson family, we all greatly sympathize with the misfortune that struck you.
Maybe somebody can give some assistance there, please.
He's giving them compliments and she's not hearing it. So
yeah, Monsieur Menard, I will start the clock from the beginning again so that you can begin again. Sorry. Can we just test to see if it's working?
You hear the English booth? Can you hear English?
Okay, let's try it again. English. Okay.
English booth? First, I'd like to thank the witnesses whom we heard this morning for their excellent presentations on a topic that is very sensitive. And first, I would like to tell Mr. and Mrs. Stevenson that I think that we're all parents here, and I had a happy marriage. My children have grown up. My daughter is expecting twins, and of course, if I thought that they were in danger of some kind of assault, I don't know how I would react, but my first reaction would be very violent. of course, and I understand your pain. And I also appreciate Mr. Bagley's presentations, the principles that he calls back to our mind. And I think that this goes in the sense of the balance that Ms. Bettel wants us to strike. But regarding my specific question, Mr. Bagley, you said that there should be a formal evaluation of the registry by an independent party. So how would you envisage this evaluation? What kind of suggestion could you give us? Should we appoint a justice of the court? I do not think that just a committee like this one can conceive the kind of evaluation that you propose. We need more investigation in greater depth because we have very little time. The time is very brief and we cannot get to the bottom of matters.
One potential possibility would be the Auditor General. I know that the Ontario Auditor General reported on the Ontario Registry in 2007. The Ontario Auditor General came to the conclusion that there was no clear evidence that the Ontario Registry was effective. You could retain academics who have expertise in social sciences, in criminology. This is a very complex issue. I've looked at studies that have been done with respect to the registry in New York State, which came to the conclusion that there was no evidence that the New York State registry is effective. This is admittedly a very difficult issue, partly, as I think you discussed on Tuesday, the challenge of proving a negative, and that's part of the challenge. But since the effectiveness of the registry is such a critical issue to your process, I really think that it would be very valuable to have an assessment of whether it's working, and if it's not working, why not, before you make significant changes. Thank you.
Merci. Monsieur Stephenson.
Mr. Stephenson. I understand that you prefer the Ontario system, but I did gather from your presentation, which was perhaps too brief, that the big difference that you see there is that in Ontario, the registry is mandatory, whereas it is, in other cases, optional. And when I read the legislation drafted for the exceptions, I find it very restrictive, and I wonder if anyone has ever been omitted from the registry. In any case, what are the other elements of the Ontario regime that, in your opinion, should be incorporated into the federal system?
Of course, the mandatory registration feature is paramount in I think any revisions being considered to the NSORIA. But in addition to that, there are other features that the Ontario model has that are well worth looking at. But I believe that in testimony earlier this week, you heard mention of the recommendation that the Ontario Registry be adopted as a model for the national, and this came, I think, out of a proposal by the Commissioner for the OPP, Commissioner Julian Fantino. But to answer your question, in addition to that mandatory order to register, I think there should be much more ability on the part of the national police force, and in this case it's the RCMP, to enforce and follow up on the registration requirements. One of the things that came out of the a very tragic case in Toronto, the Holly Jones abduction and murder, where this young girl, 10-year-old girl, was abducted, murdered. Her body was taken apart and hidden in various places. Was that the police force involved in the investigation at that time had a whole range of potential offenders to look at, and resource deployment is critical in an investigation such as that. We talk about, are there enough police officers? Probably there aren't. Some of us would like to see a police officer for every law-abiding citizen, and that would eliminate anybody from ever offending. But of course, that's something that isn't going to happen. In the case of the Holly Jones investigation, now let me get to that point specifically. They were able, within a very short period of time, to look at a range of about 60 offenders, 60 potential offenders who had registered and addresses in the immediate area, rather, surrounding the area where Holly Jones was found. They were able to eliminate those suspects within hours of the discovery of Holly Jones' body and immediately deploy those resources into more productive aspects of the investigation. And the investigation did end successfully with an arrest being made, charges laid, and a conviction won for her abductor and her murderer. That is the type of information, I think, that has to be available and accessible to all police forces. And the National Registry, if it was beefed up, if we gave it some steroids and had given it the ability to expand the database of the sex offenders, convicted sex offenders, those who we know have committed serious offenses, if we have addresses on them and we know for a certainty that those people are at those addresses, and follow-up on registration is an important feature of the enforcement component. Police officers, police services are required to do this in Ontario. Once an offender has registered, there's a follow-up procedure. A door knock is done to ensure that, yes, that was the correct address, this individual is here. And once that information is verified and maintained current, it is extremely important in investigating any crime based on of a sexual nature. So, accurate information, information that is up to date and current and has been verified. That is a component that I think should be transferred from the provincial registry to the national revision. I would like to think too that there should be more transparency between the two. There should be an ability with the Ontario Registry to have information flow back and forth between its database and the federal database, and that has encountered some serious problems in the past. But I'm not certain that I am the party to talk about in detail about the changes that should be transferred from the very successful Ontario model to the federal model. I would comment, though, if I could.
Nous n'avons pas beaucoup de temps, Monsieur Stevenson. Mais je pense vous avoir bien.
I think that I did understand that we could adopt the Ontario system, and that would be a great step forward.
Votre épouse a compris, je crois.
That your missus did understand.
A quick response, if you can make a brief...
That would be the case.
OK. Bon, donc j'aurais une question à poser à Madame Ridd.
I have another question.
1, 2, 3, and about 4 in the next round, because it's 3 minutes over. Mr. Davies, please.
Thank you. Well, I very much appreciate the physical manifestation here today of the diverse perspectives on this. We have the valid voice of due process, privacy, and the particular horrors experienced by those who have suffered the victimization of this. And I think these are all very important voices added to this discussion, along with the hearing from the police perspective on Tuesday, and I want to express my deepest sympathies to the Stevensons at the outset. I'd like to start by asking about something that the police representative said on Tuesday. If I understood them correctly, they said that there are certain specific and unique attributes to offences of a sexual nature. One of them is the need for speed. They claimed that when a child is abducted, or if there's any kind of sexual abduction, that the chances of the victim being murdered are very high within the first 24 hours. So there seems to be a particular urgency to these kinds of offences. And second, they asserted that there very often were multiple offences, whether or not those had been discovered or not. So they seem to suggest that if you caught an offender, even a first-time offender, the chances of that person having done it before on many occasions without being caught was quite high. So I'm just wondering if you have any comment on that, and if you accept those comments, if you think that those particular attributes justify a more robust approach by Parliament on this, and to ensure that the registry is tougher because of those reasons.
The one comment I would make, and clearly we don't have any expertise with respect to law enforcement, but unfortunately one of the other comments that was made on Tuesday was that, I believe it was Sergeant Nazon commented that the National Sex Offender Registry had not been used to solve a single crime. If there are ways to, from systems perspective, to make it easier and quicker to search the information in the database, to deal with the very understandable and need to get access to information as quickly as possible, by all means make those systems changes, whatever are required. But if there's 19,000, as I understand it, names in the registry now, if with 19,000 names it hasn't been used to solve a crime, would increasing that to 25,000 or 28,000 suddenly sort of make it significantly more efficient? It's not clear to me why that would be the case. And I think until you have a very clear idea of why it's not more effective, it's very difficult to get a sense of what the changes are that would make it, that are needed to make it more effective.
Yeah, I'm not sure that I heard Inspector Lauzon to actually say it that way, that the registry had not been used to solve a single crime. I think what he said was that the registry had not been in place long enough, and the data has not been compiled to draw that direct conclusion. So I'm not sure that his remarks would be interpreted quite that way. I want to move to judicial discretion. Under the present circumstance, of course, we don't have automatic registration, but if I understand it correctly, there's a reverse burden on the offender, because it would have been convicted at that point, to satisfy the court that on a gross disproportionality test, that his or her privacy interests outweigh the interest in protecting the public. I'm just wondering whether you can give me an example or a situation, maybe Ms. Bethel or the privacy people, if you can give me an example where you think an offender would not properly be the subject of an order.
There are a whole range of sexual offences under the criminal code. At a drunken office party, a person who is otherwise a very law-abiding citizen commits an indiscretion. And by that, I don't want to minimize that at all. I'm a woman, and I understand that. I don't want to minimize that at all. Would you, if we take the mandatory system in Ontario, would that sexual assault, is that an appropriate person who has committed that sexual assault, let's say convicted for the kiss at the office party, if that person goes on the registry, is that a reasonable limit on that person's freedom to achieve the objective that we're trying to achieve with this legislation? Is that for 10 years after serving that sentence, the guy who kisses the colleague at the office party, should that person's privacy be limited for a period of 10 years? Does that make sense? Is that an appropriate use of that power? I think that may be an example of one situation where it may not be appropriate, but that's up to you guys to decide.
Mm-hmm. And I also thought it was an important point to make, that it's not just judicial discretion we're talking about, but prosecutorial discretion as well. I think that would go into, do I have that correct?
That's correct. Well, currently, as I understand the legislation, the prosecutor is the one who initiates the registration. So the Form 52 is commenced by the prosecutor, and then it's the judge who decides whether or not to proceed with that procedure.
Okay, and the chair is giving me a very short period of time, so I'll just quickly get this out. The officers wanted to make the system more effective, the addition of vehicle information, and I think broadening the sharing of information among police, law enforcement agencies. Brief comment from a privacy point of view. Do you have any concerns or problems with that, with either of those two enhancements to the information collected?
With the very important caveat of the whole overriding question of the effectiveness of the scheme, adding vehicle information is a relatively minor additional piece of information of what's already being captured. Keeping in mind that does raise the issue of, it imposes the extra, since people do change their vehicles frequently, it does impose that extra compliance requirement and the administrative burden of keeping the vehicle information up to date.
Thank you. Very good. We'll now go over to Mr. McKenzie on the government side.
Chair, and thank you to the panel for being here. I have listened very closely, and I share some of the same views as Mr. Oliphant, and I have certainly dealt with a number of offenders, and I've also dealt with a number of victims. And so when you look at it from all sides, I think that we have let society down somewhat with an expectation that we have a system that is effective. And I think we heard very clearly, and I think Mr. Davies pointed it out, I think, from what we heard. But Ms. Bethel, you indicated a drunken kiss at an office party. That wouldn't result in a conviction of a sexual offense. And I think we need to make certain that what we're understanding here is these are people charged and convicted of sexual offenses. And I guess when I listen to some of the concerns, and I appreciate what the concerns are, but Mr. Bagley, I think you'd have to agree that anybody convicted of the sexual offense is generally, the name has been in the press. And frequently, the public could Google that name. What in the world would be wrong with the police agencies having that information available to them in a central system where they can access it? And the effectiveness of the program obviously won't work if we don't put the right information in. Car registration, I think you recognize that. Registration of cars is in the system now. What would be wrong with assembling that? Those people convicted of these sexual offenses have been fingerprinted and photographed. What would be wrong with having some additional information there to deal with these issues to help the police in those cases? And these are serious cases. I mean, when we have, people coming here today like the Stevensons who have experienced that, I don't know how we can say to Canadians that we're trying to protect them by keeping other people's information secret that has already been public. And I just look at this whole scenario and I think sometimes we set up bridges, and I think Mr. Stevenson used a prime example. We set up the system with not enough information and it wouldn't work. I think we heard from from all of the police officers here on Tuesday that the systems we have in place do not cost a great deal of money. We don't seem to mind spending money on other kind of registries from a federal perspective that are somewhat questionable. Why would we not want to expand this to give it the worthwhile tools to help the police community, to help our families, in many cases, come to a quicker conclusion? What would be wrong? If you could explain to us under the privacy legislation, what would be wrong in enhancing that registry with putting the information in there that's already known?
Well, let me make a couple of comments. First, as I think I suggested, we didn't come here today to advocate the abolition of the scheme. So we're not saying that you should do away with this. The issue of information being available, and one of the other concerns of our office, quite frankly, is with the amount of information that's available over the internet, the amount of information that's generated through administrative tribunals, very sensitive information about individuals. There is, however, a difference between a newspaper reporting on a crime, reporting on the conviction of an individual, and people forgetting about it from, for example, the types of schemes we have in the United States, where the information is posted on a website. We did have this situation of a young man from Nova Scotia going to Maine and killing 2 people.
But if I could interrupt you right there, there's never been a suggestion from this committee or anywhere else that I know that the intent is to make the information generally known to the public. I mean, I have a serious problem if we look at what's going on in other jurisdictions. We only need to look in our own jurisdiction and look at it, and I think we heard very clearly that we could enhance the system by only putting in more information that is already known.
Well, and I guess the question is how much more information? You have all of the physical characteristics of the individual. He or she is required to provide an address, keep it up to date. Possibility of adding information about the vehicle, we've discussed that. I don't know what, I guess it would be a question of what other information are you suggesting? The individual is required to provide information about his or her place of employment at the moment, required to provide information about aliases, distinguishing characteristics. The database contains information about the type of offenses the individual has committed in the past, the age of the victims. If there are problems with the way in which that information is made available to law enforcement agencies, then you should look at it in terms of, are there ways to make this information, which is already collected, more readily available to law enforcement agencies, provided that they have a reason to be looking at it.
Well, sir, with all due respect, law enforcement agencies have access to the information on registration of vehicles. They have information on convicted criminals. All of those things. Why would it not make sense that we put it in this particular case into a registry that deals just with these types of offenses? I mean, I understood that you, from your comments, that you've looked at the evidence that was heard here on Tuesday. I think that we heard some effectiveness from the Ontario registry, from the people in charge of it, where it has been beneficial in at least taking people out of situations where they had access to potential victims. The federal system doesn't have that capability in it. What would be wrong in importing the Ontario system into a national system that goes across the country? How does that hinder in the protection of privacy to individuals other than those who are potential perpetrators again? They've already been convicted.
Well, my understanding is the most significant difference between the federal system and the Ontario system is the issue of discretion. And we've discussed the issue of discretion. Perhaps my colleague can comment on the issue of discretion.
Good morning, sir. Thank you very much for your comments. My name is Lisa Campbell. I guess our point of view is that privacy is a constitutional right that we have to remember even after a person's been convicted of a very serious offence. They still have some rights, and it's actually in our best interest as a society to ensure that their legal rights are protected for rehabilitation purposes. We agree with you, and the Stevensons for that matter, that if you're going to establish a system like this, it should be effective. It should make effective use of the personal information that's collected. And you make a good point that much of the information you're talking about is already available in other databases. I think our main point, and I think the Stevensons as well, is get some empirical evidence on how it's working now before you make further changes.
But maybe that's our problem, is we don't have the system in place. We need to work on the system to get the evidence. But I think our Constitution also provides for the safety and security of the individual. And I think that's, we also got to look at that as being one of the tenets of this whole system. And I think we have failed because we haven't set the system up with the breadth and the depth that needed.
To that a little later. Okay, Mr. Holland, please.
Thank you, Mr. Chair. I want to start by thanking the witnesses for the intelligent and sensitive way in which they approach what is a very difficult, sensitive topic. I particularly want to thank the Stevensons for all the work that you've done. It's a great tribute to your son and everything that you're doing, and it really is remarkable. I thank you for appearing today and for all the work that you've been doing. I want to just start with a point maybe before I go to my questions, because we can't really address it today. I think one of the things that we do have to underscore in this, because I do very much support the sex offender registry, but I think it's also important to not hold it out as a panacea, that it unto itself is going to solve the problems. And oftentimes we talk a lot about enforcement, but I don't think we spend nearly enough time talking about either prevention or rehabilitation. And I think it's an area of great failure that we have to be a lot stronger on. So when we're talking about enforcement, I think it's important to hold our minds to that topic. With respect to data, one of the things that I'm trying to look at is in the Ontario example, where there's an automatic addition as opposed to judicial discretion. The example, Ms. Bethel, that you gave, to me, strikes me as sexual harassment, not a sexual offense, as it's been defined as an example in Ontario. Ontario has got a very defined sense of what a sexual offense is that certainly would preclude, say, the example that you gave. I'm concerned that there are so many people being left out of the system and being left out of this registry because, again, it's not being publicly disseminated. This is for the information of police officers. I'm wondering, though, because right now under the federal system, we have a number of things here that are a little sticky, and it would be hard to know exactly how to pinpoint. For example, in the right now the federal registry, you can have trespassing at night, breaking and entering listed, and I'm presuming the intent there is that if you're breaking and entering with the intent to commit a sexual offense, then that puts you onto the registry. Yet I don't see that in the provincial law. I mean, how do you? I mean, it seems to me that the province has taken a very narrow view of looking at this, and that the federal legislation is much broader, and maybe that's why it's not automatic. So if we were to do what Ontario did, which is to make the list of offences more narrow and have it be automatic, would that assuage some of your concerns? Or is there a way of maybe dealing with some of these so that we can make sure that they're caught? Because I share the concern that a lot of this is not being picked up in the system, and personally I don't believe it's somebody kissing somebody at a work party.
The offence of sexual assault encompasses a wide variety of behaviour, and what's called the actus reus of the offence, which is the actual act and not the intent involved, encompasses a wide variety of behaviour which can be determined on the basis of circumstances and things said, what is done and in what context. what the relationship is between the two. And so, in fact, depending on the circumstances, yes, where there's no consent, an indiscreet and inappropriate kiss at an office party can be deemed sexual assault.
Okay, but let me just to be clear, and I'll read. I won't read them all, but I'll read some of the ones. Sexual offense against a child by a Canadian citizen, sexual exploitation of a person with disability, accessing child pornography, luring a child by means of a computer system, stupefying or overpowering for the purposes of sexual intercourse, living off the avails of prostitution, purchasing sexual services of a person under 18, removal of a child for Canada for sexual offense purposes, rape, commit to attempt rape, indecent assault on a female. I guess that's the one that you would have concern with then? I mean, is it possible then?
Are you reading from the Ontario
This is my example, the Ontario one, because
okay.
my point is that to address your point, Ontario has made it much narrower. They've said these are the offense we deem to be a sexual offense for the purposes of putting somebody on the registry. So if we're looking at this issue of automatically being placed on the registry, isn't part of the solution having a narrower list of definitions, as has been done in Ontario, to ensure that we preclude the type of situation that you're stating, while also dealing with Stevenson's concern, where you have, you know, a very large number of people who don't seem to be putting on the registry right now.
Yes, I was getting to that. The National Sex Offender Registry, the designated offences under the National Sex Offender Registry right now include, as you say, a wide variety. And so I was just addressing your comment about whether or not a sexual assault would put a sex offender on the National Sex Offender Registry. I know much less about the Ontario law, so I'm afraid I can only talk in generalities. I think that may be one way to be able to strike the right balance in terms of not casting the net so arbitrarily wide as to encompass all offences, you know, all variations of assault. And so that is one possibility. But I think there are other ways to make the National Sex Offender Registry more effective without making it mandatory. So, for example, one criticism by some of the members of the Council who work right across the country have told me that one improvement to the registry might be to list the factors that a judge could take into consideration when putting an offender on the registry. So right now, there is no enumerated list. A judge can take into account a wide variety of factors, and that is discretionary, and it's up to the judge to make that determination. But one of the, and that may be a good thing, but one of the arguments or criticisms of that is that the law is applied inconsistently. So in one case, a judge might take into account some factors, and in another case, the judge may not take into account those same factors. So one possibility, rather than a mandatory list, might be to take keep the list of designated offences, but make the factors that a judge takes into consideration when making the determination of whether an offender goes on the registry enumerated.
Mr. Norlock, please.
Thank you to the witnesses for coming this morning. We've heard, as a matter of fact, some very good evidence. But last night, when I was having the second part of my evening meal at my apartment, I just happened to be needing some brain candy, and I didn't get any because there was a program on, and it had to deal with one of the more popular police-type shows. And it had to deal with the very subject matter that we're talking about here today. And I couldn't help, because we had heard earlier on in the week some of the testimony of the police witnesses, and then this morning, of course, we're building on that, and we're dealing with some issues. No one, I don't think, whether they be police officers, defense counsel, prosecutors, judges, or even victims for that matter, would want their personal privacy to be exposed to the extent that they would really have none. And that's not the purpose of this registry, at least as far as I know. Nor would we want to restrict the ability of judges to exercise discretion But we have, in the view of many people, I believe Mr. Stevenson, that discretion has gone beyond discretion, and it's gone to the point where the weight of the needs of society and the victim seems to be tilted, seems to be still tilted towards the need of the accused and the individual. We get so worried and so bound up in making sure that the person who has perpetrated the crime, and in this case on conviction, so we're not dealing with somebody accused, we're dealing with somebody who's being convicted, that we seem to forget that the purpose of this registry, or we get caught up in so many of the other what we believe to be exigencies surrounding, that we forget what the purpose is. And this program sort of had some very similarities to what the police said and some of the things. Number one, the first few hours of the investigation are crucial. Now, we're dealing with, the office kiss in that, and I'm going to allude to that, and then I'm going to ask for some comments from the Stevensons. But the first few hours are crucial if you're going to want to find that victim or that abducted person who will be sexually assaulted. The first few hours are very critical. And that's the whole purpose of the registry, is to give the police a tool. When we talk about the efficacy of the program, of the registry, it's not designed to catch. It's not designed to solve the case. It's designed to assist the police in honing in and narrowing in on a select few individuals who might be the perpetrator of the crime, and then solve it. So it's only part of it. And that, I guess in that way, it's very difficult to quantify. It's very difficult to say how good it is, except to ask the very people who use it and who do the investigations. And if we look at their testimony leads us to a few things. Time is of the essence. As much information as can be gleaned from the convicted persons, their habits, their sexual preferences, their sexual appetites. And then, of course, the very significant part is, where do they live? Because that's going to narrow in where the crime occurred, et cetera, et cetera. The other thing it does, of course, you bring in people like profilers who help at that. I guess my question to the Stevensons will be this, and I don't want you to go into something that would be very difficult for you emotionally, but just talk about how the system that you would like to see, and it sounds like a system similar to Ontario with a few things better. How do you feel, based on your experience in your case and similar cases that I'm sure you've looked at? How do you see what happened to you, and your family? Do you think there would have been a more successful outcome were there a better system? I would like you to comment on that.
Thank you. My immediate response to that is yes, I think there would have been a very definite different outcome. In our case, Christopher was abducted from the mall on a shopping trip with his mother and younger sister, and he was taken from the mall to the offender's residence. He was held there against his will for approximately 36 hours in an address and a location which was probably about a block away from where we lived and continue to live to this day. It was at the end of that 36-hour period that his attacker, the man who murdered him, decided that he had no alternative unless he wanted to go back to prison, but to do away with Christopher, to end his life and prevent him from testifying or identifying him should he ever be apprehended. And that was his whole operandi. Today, if we had the sex offender registry that is in place in Ontario and is a role model, a state-of-the-art role model, I think, for registries in any other jurisdiction, the outcome would have been very different. You talk about time being of the essence in an investigation like that. Police were on the scene within about 3 minutes of Christopher's abduction. They responded very quickly. but did not have much information to go on. They had no information on registered or on sex offenders who were living in the community, although by order of his release from the institution, Fredericks, who had abducted and murdered Christopher, had registered his address with police services, as he was required to do. They had no access to that information. It wasn't contained on a database. It was contained in the local police station where he registered, and it was confined there. It was held basically in a Hilroy exercise scribbler. That was where the information was stored. Today we have a database with IT support that is par none. It has no comparison. That information today would have been available to officers immediately on the response to the call to the shopping mall, and within probably minutes they would have had a list of known sex offenders, child molesters. Fredericks had been convicted of a sexual assault on a young boy in this very city some 3 years prior to his abducting and murdering Christopher. So he had a record, and his information would have been available to police officers. I mentioned being held for 36 hours. Certainly their intervention would have taken place much earlier in that time frame, and the outcome would have been much more satisfactory to his mother and myself.
Okay, it's out of time. We'll now go over to the Bloc Québécois. Monsieur Menard, you want to continue? Mr. Goudet? Okay. Mr. Goudet, go ahead.
I just have a brief remark, and after I'll give the floor to my colleague. Because my colleague, Mr. Mackenzie, for the registry of the sexual offenders, I observed that I'm not very informed about justice, so I'll leave my colleague to carry on putting questions, and if you want to answer, thank you. Well, the question I wanted to put was already put by the representative of the new party, but I'd like you to elaborate a bit more, because as you said, and I think that we've recognized, I've been in this field for over 30 years. I was Minister of Public Safety in Quebec and the Minister of Justice in Quebec, so I'm quite familiar. I think that the fact that sexual offenses are committed by people who know each other. And I think that your practice has shown up more examples than this undesirable end-of-year party kiss. Are there other situations where you think that registry of sex offenders would have no efficiency whatsoever when it comes to solving other sexual crimes that might be committed?
Thank you. My answer to that question is that I don't know what crimes or offenses the registry would be able to solve or prevent. And from the research, what little I do know about the registry, and albeit it's little, I have yet to see any empirical evidence that it works for any offense. That's not to say that I don't think that it could. It's very possible, and I'm open to that. It's just that in order to be satisfied that we are conforming with the principles of fundamental justice when we enact certain laws, that we are doing so with not too broad an objective, and that we have an understanding of what it is that the legislation is going to solve. What is the problem that we're going to solve? Is there evidence that a particular solution will solve that problem? I haven't seen it. I'm open to seeing it, and I hope that the registry will solve some problems, but I wonder where the evidence is that it can, does, or will. But it's true, if a first offender commits an offense, the registry will not catch that person because that person has not been convicted before. So the registry is just for someone who has been convicted before. So the issue is reoffending, not the global idea of the offenses themselves. And of course then, as we know, the vast majority of sexual offenses occur between people who know each other. The horrible tragedies where it is an offense committed by a stranger are in fact rare. That's not to diminish that we shouldn't be very alive to doing everything we can to prevent that. But again, we have to maintain the perspective on what the levels of incidence are of that vis-a-vis what kind of solution we design to address that problem.
Oui, j'ajoutais ça avant de...
I'd add, before saying that I would basically put the same question to Ms. Campbell and Mr. Blackley, but I think that we all agree about the fact that the kind of offense or the kind of offender who assaulted young Stevenson is a striking example of the potential usefulness of the registry, and I think it's very clear that all the examples raised by my colleague are also cases where there is no problem. But actually, we know that most sex offenses that are not reported in the press that are in court are between people that know each other, either family or work or teachers, students, etc. And of course, sometimes people fall in love, and they should not be prosecuted. This is a case with some professional relations, and it's been classified as a sex offense. I think that Ms. Campbell is ready to answer these concerns. Yes, thank you very much. You've raised some very important points. What is the objective of this legislation? As Ms. Bethel said, a vast majority of sex offenses happen between people who know each other, sometimes in a family setting, and very often young people who have never offended before. And Ontario aims at a more restricted list of offenses with the intent of helping the police, whereas the federal legislation has a more broad range of offenses, and also the kind of offenses that could be committed by people before they seriously offend. So what do you want to do, basically? Do you want to help the police to detect serious crime before, or do you want to eliminate suspects? So there's a distinction between two models, and the current federal model could also help in prevention of serious offenses while still respecting the privacy. Yes, I think that I could answer your question myself as well. I think that we'd all want to have prevention as well as prompt prosecution. But let's say a psychologist with a patient or a teacher with a student, without any great difference in age, but the student is after all a minor, these are all called sexual assault.
And go over to Mr. Rathgaber, please.
Thank you much, Mr. Chair, and thank you very much for all of the witnesses. Especially like to thank Mr. and Mrs. Stevenson for coming here and sharing your story and your passion on this very important issue. I am somewhat troubled by some of the comments that I heard from the Office of the Privacy Commission, and I'd like to go there first. Mr. Bagley, I accept the premise that society and we as parliamentarians must balance privacy versus the value that a sex offender registry brings to society. But I suggest to you that it becomes a self-fulfilling prophecy that a sex offender registry is going to become ineffective if, by statutory definition, you limit its scope. Now, we've heard some suggestion that the Ontario registry is more effective because it is more exclusive, and therefore, by definition, the National Registry is less efficacious because it is more restricted. So, I guess my questions are twofold. I mean, do you agree with my premise that if you restrict its application to such a narrow, or to making it optional at the discretion of the judge, by its very definition, you're going to capture less offenders?
Well, I have a couple of comments. First of all, on the issue of discretion and the percentage of offenders who are in the National Registry, one of the things I would suggest is that you try and get a very clear sense of why you're not capturing a higher percentage. Is it because would a reasonable person look at it and say, these are cases in which the judge reasonably exercised discretion? Is it cases of plea bargain? Is it cases of the prosecutor not even asking? So you should have a clear sense of why you have a much lower percentage.
Right. And the registry's only existed for 4+ years. So it's still in its infancy, especially compared to the Ontario registry, which has been with us nearly a decade.
That's a fair point. But with respect to, I guess, the heart of your question is whether too much focus is being placed on the privacy rights of the offenders, and therefore, by definition, you've built in failure. Again, going back to the point I made earlier, it seems to me that a huge amount of information is already collected about the offender, and I would ask what additional information you're proposing to add. If there are problems with respect to police agencies not being able to access this, or if the system isn't structured in such a way that it's not easy and quick to search the registry, then by all means make those changes. The worst possible case is to have this information to have intruded on the privacy of the individuals by collecting this and then have a system that doesn't work. You either make it work, preferably by measures that are as least intrusive as possible, or you come to the conclusion that by the very nature of the offenses, this type of registry is not going to work, and come to that conclusion.
And on that point, we agree. I think we have to make it effective if we're going to compromise on the privacy rights of individuals, and it's certainly my motivation, and I think of all of my colleagues, to make it effective. And Ms. Bethel, I want to challenge you on this hypothetical analogy that's been the subject of some questioning here, and that's the office kiss. And I thank you for lending me your criminal code, which confirmed what I suspected, and that's that sexual assault, Section 271, is in fact a hybrid offense, and the Crown has the discretion to proceed by indictment or by summary conviction. You'll agree with that?
Yes.
And so is not the solution to this problem, if we were to make registration of the designated offenses mandatory, such as it is in Christopher's Law in Ontario, isn't the solution to make the discretion in the trier fact limited to those convictions where the Crown has proceeded by summary conviction? Doesn't that solve the office kiss problem?
It may solve the office kiss problem. It may solve the idea of sweeping up arbitrarily all persons into the registry who may not be appropriately there. That may solve that problem, and that's something to consider. But again, the issue with making it mandatory is that it leaves the prosecutor and judges without any discretion at all. And so right now in the criminal justice system...
But the prosecutors have the discretion to proceed by summary conviction.
Pardon, sorry.
The prosecutor has the discretion to proceed by summary conviction.
Right, with respect to the Ontario Registry. And so you're saying that a summary conviction
with
offense...
respect to any sexual offense anywhere in Canada, if it's a hybrid offense, the prosecutor has the discretion to proceed by summary conviction.
Yes, they do.
Thank you. So you're not taking away the Crown's discretion?
I'm sorry?
You're not taking away the Crown's discretion on a hybrid offense, is my
No, the
question.
discretion is with respect to the registration is what I'm talking about.
Thank you. Is that my time? Thank you.
I'm so absorbed in listening here that I wasn't watching. Yes. I have a question. I was hoping in all the rounds of questioning that we would come back to something we heard last Tuesday, and that is that in the U.S., the public has access to who is living in their communities. Could you, each of you, give me a brief comment on whether you would agree that it would help in protecting the public if they had access to the information that is contained in the sex offender registry? If each of you could just give me a brief comment on that.
Well, I'll come back to a comment that I made in my opening statement, which is that in a democratic society, we make the decision for the prosecution of offences and the investigation of offences to be undertaken by the criminal justice system. We don't undertake that obligation or responsibility ourselves as individuals. And so, in my view, that would be an impermissible breach of privacy rights.
Okay.
There were already provisions under the Criminal Conditional Release Act that allows, on a case-by-case basis, information to be released to local police forces into the community when someone's released who's considered to be a threat. We would much prefer this to be dealt with on a case-by-case basis as opposed to making the registry open.
Okay. Mr. Stevenson.
Thank you. Just prior to commenting on the question, I make another comment, and that being that I'm absolutely stunned by the amount of attention that has been paid to this office kiss scenario. We're talking about the National Sex Offender Information Registry Act, which covers a range of offenses, sexual offenses, from homicide to an office kiss. The majority of the offenses that are for which convictions are brought down fall well within those ranges. And to spend the amount of time that we have this morning on discussion about whether or not an office kiss, the offender should be placed on their registry is just stunning. However, having said that, as registries in other jurisdictions, whether or not the information should be made public, we were approached with that question at the time the Ontario Registry was in its conceptual state. And our advice on that was no, absolutely do not make it public. The last thing we need to do is put information about offenders who may or may not be guilty of a particular offense that is being under investigation, put that information in the hands of the public. Particularly concerned family members who may take the law into their own hands and do something that they would regret and society would regret at a later date. I'd like to make another comment, too, on the registries that exist in other jurisdictions, and it seems to have been something that someone has kind of thrown up on the wall, and it seems to have stuck, that the Ontario Registry, compared to other registries in the States, doesn't seem to have the same kind of power of police search capability or the ability to assist on an investigation. I would think that Ontario's model is, as I've mentioned in my presentation, state-of-the-art. Registries in the States in various jurisdictions south of the border range from notebook information maintained at various central police stations to Hilroys that go absent and are taken home by officers who are involved in management of the information, to models that are similarly computer-based as Ontario's is. So to compare apples with oranges is a mistake. And I would think that if we look at the success or lack of success of models in the States as a benchmark for what we should be doing in Canada, we're making a bit of a mistake. And we're shortchanging the ability of of a model that is based on current IT and is aggressive and proactive. The jurisdictions in the states cannot boast similar models in operation in their investigations.
Thank you very much. Mr. Kanya, please.
Thank you. First, to the Stevensons, I'd like to sincerely say that I'm very truly sorry for your loss. And in terms of why we're here today, my perspective is we have to develop a system that is as strong as possible, taking fairness into account and privacy issues. But unfortunately, we're here 7 months after amendments were already passed. And I think most of the members of this committee would agree that when Bill S3 was proposed and passed under the leadership of the Conservatives, that they left a number of problems unsolved. So what I'd like to discuss is those problems and how we best can develop a system that focuses more on prevention. Now, we've discussed mandatory inclusion, automatic registration, the use of the system proactively so that they actually can try to find people who have been abducted as one example. Identifying people, I find it quite amazing that under the system, the amendments, they didn't allow for warrants to be issued or publications for people who have not registered as they're supposed to do. The failure to use license plates of vehicles, I can't understand that either. So what I'm looking at is something that tries to fix these problems that were left unresolved when the Conservatives passed these recent amendments 7 months ago. So what I will ask the Stevensons first is, I know you say the Ontario system is state-of-art, and I know that it's much better than the federal system. So my first question is, do you think there are any ways that the Ontario system should be improved so that we would take that into account when trying to do something else now?
In response to that, you mentioned the amendments that were introduced, legislated about 7 months ago, and I think they came at as a result of the findings of the Auditor General, who had done an audit on the sex offender registry, and he mentioned a number of shortcomings and gaps and soft spots in the existing legislation at the time, and I think the provincial government's response to that was to move to close those gaps and loopholes as he had suggested in his report. Beyond that, I'm not aware, and I can't recite any further enhancements that we would submit here today. No.
Okay. Thank you. In terms of the Privacy Commissioner, in your report, there's a comment that you made here. There may be ways to make the scheme more effective through increased resources or through procedural changes that would enhance the effectiveness and value of the legislation without increasing its intrusiveness. So when I read the words without increasing its intrusiveness, I read don't put mandatory inclusion and all these various problems, don't remedy them. So what I'd like to know from you, whether it's today or through a written response at some point, is what you would suggest in terms of trying to improve the system to the strongest possible level without violating privacy rights that you would be obviously responsible for. So that is something I want to address, and I'm going to suggest one potential compromise. If the legislation is made stronger, and I'm not going to suggest what should be concluded, but if it's made stronger to try to address some of the problems, what about the potential compromise? Because right now you have Section 17 of the statute, which provides penalties for the improper use of the information. So one suggestion, perhaps, and I'd like to hear your opinion on it, would be to make that even stronger, to really provide a disincentive to anybody to improperly use this information at the same time that we're strengthening the legislation to make it more helpful for prevention-type activities. So I'd like your comments on that.
I'll be brief. We're not convinced that that would necessarily be more effective unless we have some reason to believe that there's a problem now with the information being misused. From our perspective, the privacy intrusion is not about the misuse of the information in the registry, but rather about the collection of the information, the monitoring of the individuals, and that's why we're saying that there needs to be a balance, and one way to look at the balance is to assess its effectiveness. In terms of ways to make it more effective, certainly resources is one possibility. I suspect that one of the problems with the scheme is ultimately it's a national scheme and not a federal scheme, that much of the day-to-day work is actually not done by the RCMP, it's done by local police forces. How you get them to cooperate, how you get them to take a more active role is likely to be a challenge. Are there systems, ways that would make it more effective? One of the problems I understand is that when the year is up and the individual has perhaps not registered or re-registered, my understanding is that there isn't a simple systems way of identifying the fact that the person has failed to re-register. Are there ways like that to address some of the problems that would not increase the intrusiveness?
I'm sorry, we're going to have to continue to proceed. I just want to make the committee aware, and I'd like to welcome the group of grade 9 students that have come to observe the proceedings of this committee. They're from the Woodbine High School in Toronto, and I believe they want to see how Parliament works outside the House of Commons, and I would hope that they will see that there is some real serious work that goes on here that is generally not as political as what they would normally observe. So welcome. We appreciate you coming to take the time to observe what we're doing here. Thank you. That comment you heard was, "We are the best committee." I won't object to that. Okay, thank you very much. We will now go over to the government side. Mr. McKenzie, for a moment, you're sharing your time with Mr. McCollum.
Yes, I am, Chair. And for the benefit of the public that are watching, because this is televised, I just want to make two things very clear here. Mr. Kanya spoke about the amendments that were just made and why these things weren't fixed. From this side, we would say it's a shame that the federal policy didn't mirror the Ontario policy when it was implemented by a former government. But the other thing that's perhaps even more important, Mr. Chair, is I don't want to leave the impression that the government is looking at making this a public, accessible document or a system. And I know that was not your intention. You were simply asking for clarification. But just so that there's no misunderstanding, it's not the position of the government to make this accessible to the public.
Thank you. Thank you, Mr. Chair. And I, too, want to say to the Stevensons, we will never understand, any of us, what you have experienced. Your courage and your wisdom to your public witness speaks volumes. And I want to thank the other presenters as well, because you provide a very stark contrast to this issue and to the protection of the perpetrators. See, public safety, in my mind, happens every day, every second, every hour. The issue of the sex registry reminds me of the poster. It's a picture, actually, used by firefighters in promoting the need for working smoke detectors. And many of us have seen it. It's a firefighter standing outside of a charred building holding the body of a charred baby. We have a smoke detector that isn't working. It does not have batteries. It's nice to look at, kind of makes you feel good, gives you a sense of security without actually being the case. I was shocked, and I'd like my question now to be to whoever chooses to answer, to hear that 50% of the people who actually are convicted due perhaps to judicial discretion, I believe that's what the comment, Mr. Stevenson, you made, do actually not end up being put on the registry. Would you like to comment further on that, sir, or would you like someone else like to comment on the reason for that?
No, it's a matter of grave concern, and the fact, add to that the fact that the legislation requires that when judicial discretion is exercised, and the judge determines not to proceed to issue an order to register, he is required to document the rationale behind his decision, and in fact that is not being done. So to go back and, as one of the witnesses suggested, to review the reasons why some of these decisions or the discretion is used to the extent it is, review the rationale, I doubt whether you'd find much success in that type of an exercise because, quite simply, there is no narrative provided on the rationale not to issue an order to register. But I'd be very interested in what the response from the other witnesses might be.
Would you like to comment?
I continue to think that there might be value. One of the things that, at least according to some reports, is that there's plea bargaining. There is failure of the prosecutors to make the request. I think it's very useful to separate out what a third party might view as a reasonable use of judicial discretion from other reasons. It's a striking figure that whatever it is, sort of almost 50% of the offences are not on the registry. And I think it's very important to know why that is the case. Again, sort of I note from the experience of the DNA Identification Act, which also has discretion built into it, that over the course of the life of that scheme, the percentage of people who are now providing DNA has steadily increased. In other words, the percentage of people who are not required to provide DNA has steadily decreased as the law has come into force. One of the things that I understand that has worked there is that there has been some attempt to work with the judiciary to make them better understand the legislation.
Okay, and I'd like to address, if I can, Mr. Chair, my second question, actually to Ms. Bethel. And you had mentioned in your opening comments about the balance of budgetary constraints against the benefits and such, and weighing that. And I'm wondering if you are aware of the cost of per annum that it costs to actually run this registry.
Yes, I am. And at present, I understand that the resources are not high. Okay. But if there were to be further amendments, then it's an open question as to whether that would increase the costs. And if resources are going into the registry, and that may be a valid value-added thing to do, I just question what the balance is between putting money into the registry and whether there's money being taken away from other sides of the balance sheet. Taken away, for example, from rehabilitation efforts, from probation, and those other kinds of social integration efforts.
Now, if I might just, Mr. Chair, put on the record that the actual cost is approximately $400,000 a year to run the registry.
I've seen numbers ranging from 400 to 600,000.
Yeah, 600,000.
So, yeah.
And initially, the registry, I'm a new parliamentarian, but was apparently $2 million to set up. So in a comparative sense of other registries that we've been discussing in Parliament, I just want to put that on the record as a frame of reference.
I think if I can just comment to that, this is probably a little provocative, but the gun registry, of course, is an example of when I realize this is regulation of guns and not people, but it is an example of something that can take on a life of its own when resources are put into a registry like that. I think you make a valid point.
Mm-hmm. Thank you.
An excellent point, ma'am. I must say that just needs to be stated very clearly. $85 to $90 million for. I just wanted to point out to the students that are watching here that one of the purposes of a committee like this is to review legislation to see how effective it is, and what we are doing today is reviewing the sex offender registry. And so I just wanted to put that in context to help you understand one of the purposes of parliamentarians is to ensure that the laws that we put in place that Canadians have to live by are effective. And that's what we're doing here in committee, and many committees do that same thing. I have only a request for one more brief question for Mr. Kanya, and then we'll wrap up this meeting.
Very brief follow-up in terms of the Privacy Commissioner Office of. Once again, the comment was there may be ways to make the scheme more effective through increased resources or through procedural changes that would enhance the effectiveness and value of the legislation without increasing its intrusiveness. Can you please provide us with something in writing with specific ideas that you may have? I think we should take them into account, but I think that that sort of comment needs to be concrete in terms of how we would improve this. Thank you.
Yes, we will do that.
Okay. Does anybody have one very brief closing comment from any of the, Mr. McKenzie?
Not about this, but I wonder if we could have 2 minutes after.
Okay, well then we'll better wrap this up because I think there's another group waiting. Mr. Stevenson, you indicated you have a little comment?
Maybe if I could, I always like to have the last word, and since I've been invited, one of the concerns is the cost of the registry, the cost of maintaining it, administering it, and is it maybe in the better interests of society to put those dollars into preventative or after or treatment programs? And I would think that I'd have to say, and I've had this discussion with police officers, I've had this discussion with offenders in the institutions who are there because of convictions for sex offenses. And they appreciate the fact that the sex offender registry allows the sex offenders, or reminds them that somebody is watching. And if that isn't preventative enough, I don't know what else can be suggested. But certainly convicted sex offenders have confided to me, and I know that they can be a manipulative population. But I believe that they are sincere when they have confided in me that they appreciate very much the fact that they are required to register. They know they're going to have a policeman knocking on their door to verify address and verify that they are not taking up residence in an apartment building that is full of children that are under the age of 8 or under the age of 14. And that is kind of a preventative offshoot, a very beneficial offshoot of the sex offender registry that was not anticipated, I think, at the time it was crafted and put into place. And that would be my final comment.
Thank you. Mr. McKenzie, did you want to go in camera in your 2 minutes?
It's not necessarily, no.
Okay. The witnesses may excuse themselves, and we'll just continue with our business here. Thank you all very, very much for appearing. We've appreciated your testimony very much. Go ahead, Ms.
The only thing, and to the committee, I think we have 2 days where we maybe not anything blocked off.
Yes.
And we'd had the witnesses the other day talk about coming back in an evening. And I know we've talked to some people and found out that most folks feel their evenings are pretty tied up. And I'm wondering if we could have them come in and do a demonstration, the Ontario people.
A demonstration.
I'm wondering if we could use one of those days and have them come back and do a video with a.
Okay.
I think it'd be beneficial, and if it fits.
Okay. I'm going to set 15 minutes aside on Tuesday to discuss future business of the committee, and let's keep that in mind for the 14th.
Yeah. Okay.
Okay. I have a suggestion for the 12th and 14th, and we can discuss this all next Tuesday. Okay? Yeah. Did anybody else have anything? This meeting stands adjourned.